Good morning, everyone in the room. Welcome to House Judiciary. We have two bills before us this morning. Just a few preparatory comments before we get going. We treat each other with respect in this room. We will maintain decorum. People who are out of line will be asked to leave. Are we clear on that, how we work in here? It's just the Wyoming way. Yeah, you know, if we're polite to each other, we can disagree vehemently, but we do so in a polite manner. And that's the expectation in here. Secondly, it's important when people are testifying that the green light be on your microphone so that the people out on YouTube can hear your voice as well as the people inside this room. Okay. When you come to the microphone, I'll ask you to identify yourself, where you're from. It's always helpful if people know that you're from someplace in the state or whether you've come from someplace else to testify in the morning. With that, why don't we call the roll?
Representative Brady.
Here.
Representative Bratton.
Here.
Representative Chestek.
Here.
Representative Filer.
Here.
Representative Kelly.
Excused.
Representative Lean.
Here.
Representative Singh.
Here.
Representative Webb.
Here.
Chairman Washut.
Here.
You have a quorum.
All right. We begin with House Bill 8 committee. You're all familiar with this. This is a joint judiciary bill that we worked over the interim. Straightforward bill that adds one sentence to our stalking statute. We have some witnesses this morning who will refresh our memory on the underlying matter that gave rise to this legislation. And then we'll jump into the bill itself. So anyone wishing to testify with regards to House Bill 8? Good morning. We're all friendly people. We don't bite. So speak up and tell us what you'd like us to hear about the situation.
Good morning, legislators, and thank you for this opportunity to speak before you again about Wyoming's current stalking laws.
Mr. Chairman, you have to remove that microphone just a little closer.
A little closer.
Back here and introduce yourself.
Oh, my name is Jillian Holman. I'm from Glen Rock, Wyoming. Me and my current boyfriend were stalked from November 2023 to October 2024 by a 40-year-old woman in our community. I'm aware that you are familiar with the main details of the case from the previous times that I have testified, so I won't waste your time today with that information. Today, I'm here to talk to you about the mental health aspect of being stalked and how being stalked has continued to affect me to this day. I was told by our victim advocate that the human brain will often forget or not form memories when it is experiencing something traumatic. It is a well-known coping mechanism and one of the ways our bodies help us survive difficult times. I never thought that it would happen to me, but it did. When I look back on the year I was being stalked, it's hard to remember a lot of what happened, both good and bad. When I look back on my sophomore year of high school, it feels like a fever dream. When discussing the year I was being stalked with friends and family, I realized that I can't remember conversations, important moments, and details to day-to-day life. What I do vividly remember is how I felt. I lived in a constant state of terror to the point where someone from the outside looking in would probably consider me paranoid. I wasn't allowed to leave the house much during the year I was being stalked due to my parents' fear for my safety, and I soon found myself sharing that same fear. I didn't want to go to school or to any events around town. I hated competing in sports because those moments in my life were often targeted by my stalker, and I would receive texts from her while I was competing. My mind was frequently focused on being stalked, and it affected how I performed. Wrestling is a mentally strenuous sport. If you lose a match, you can often find yourself having to wrestle again within an hour. I was struggling to recover mentally from losses, and even while competing. I was thinking about my stalker and if they would use that specific moment against me. I remember the point when I finally realized how bad being stalked had affected me. I was at state FFA, and I received texts that were so specific and vulgar that I thought I was about to get raped or killed. I was scared enough that I was shaking, crying, and trying not to throw up. I wouldn't even leave my hotel room. unless I had a trusted friend with me, a pattern that I still find myself falling back on. Once we found who was stalking me, I assumed that life would be easier and I would feel safer. In some ways, life was easier. I knew who to look for, and I knew that law enforcement was on our side. What got harder was facing the truth that being stalked had changed me. At one point, my mom wanted me to go to a basketball game to watch one of my friends. Instead of being excited, I cried and argued with her, insisting that I didn't want to go and that it wasn't important to me. My mom insisted that I go, and I went along with me to the basketball game so I'd feel safe, something that she had never had to do before. I found myself making excuses to not go out with friends. I contemplated quitting wrestling, a sport I love and have dedicated countless hours to. Again, my parents intervened and forced me to compete. At first, I was angry with them, but now I am grateful. Even as recently as the past month, I continue to recognize how much being stalked has changed me. As I sat down to write my testimony for today, I found myself crying and shaking simply while looking back on how it felt while being stalked and how it affected me. No one should ever feel as scared as I felt, and no child should have to suffer the mental toll of an adult's criminal actions. If it wasn't for the support of my family, my boyfriend's family, and law enforcement, the story could have ended differently. I can't imagine what it must be like for younger victims of stalking who don't have access to the support and resources like I did. We need to protect Wyoming's minors, and one way to do that is to vote yes on House Bill 8 and to encourage your fellow legislators to do the same. This isn't about making the punishment fit the crime. It's about protecting Wyoming's children from adults who abuse their position of power and seek to harm them mentally in ways that will continue to affect them for the rest of their lives. Thank you.
Thank you. Anyone else at the table want to talk?
Council members, Dan Holman from Glen Rock, Wyoming. I'm Jillian's father. Thank you for allowing me a few minutes of your time today. I appreciate the support that you have given from the beginning to now and the continued support that you will be given moving forward. Earlier this year, we were able to testify in your committee hearings about the stalking case involving my daughter, Jillian, and another minor, Preston Sorensen, who's here with us today, by Marcy Smith, an adult from our community. I truly appreciate the efforts you have made so far with the LSO to draft the amendment to Wyoming's current stalking statutes. I know that you have very pressing budget issues you are facing, and there's a lot happening over the next few weeks that will command much of your attention, but I'm asking you to please keep House Bill 8 at the front of your efforts. Wyoming and its children need this protection in place. In the fall of 2023, through no choice of our own, it felt like my family was thrown into the deep end of a pool. In short order, we had to become vocal advocates for our daughter. We had to learn how to navigate the courts. We had to adapt our lives and sacrifice our time with our other kids and our jobs to make sure Jillian was getting the care and support that she needed. We had to learn how to navigate the mental health effects of stalking, not only with Jillian, but with each other as well. Until a family has been through an ordeal like this, you have no idea how much it can impact the loved ones in your home. Watching your child hurt for somebody else's pleasure makes a mark on you. I've looked back and thought about this case a lot. There are things I would have done differently, things I would have softened on, and other things I would have fought harder for. Hindsight's 2020. One of the bigger challenges we faced in the middle of this mess was when Marcy Smith, through her attorney, filed an amendment to the bond conditions set after she had pleaded no contest. Her attorney filed for a temporary bond condition that would allow her to attend state wrestling, where Jillian and Preston would be competing. The county attorney's office approved this temporary amendment. The original bond conditions called for no contact with the kids, and with the approval of the bond amendment, she was given an avenue to be near the kids at state wrestling. Herein lies the rub. At our protection order hearing, which is a civil proceeding, it was specifically discussed that she would not attend any of the events where Jillian or Preston were competing in wrestling because she had previously targeted the kids at those events. In her attorney's views, the bond modification allowed her to attend the event, which would in turn put her in close proximity to the kids. We were never notified that a motion to amend the bond had been requested, and we were never notified that it had been granted. Purely by chance, we learned about it, and thankfully, we had enough time to use our protection order to stand our ground and keep the kids away from her. I feel that had this been charged as a felony from the beginning, that the bond conditions would not have been modified, and that had there been the request for a modification, we would have been notified, so we could have taken the steps to protect these kids. Please keep pushing House Bill 8 forward. Please work with your counterparts to keep it clean and simple. Do not let it get lost in the shuffle. Thank you again for your efforts. We appreciate them, and the kids you will be protecting appreciate it as well.
Thank you. We need to make sure we only have one mic on. Is that what's causing the feedback, you think, or we're getting a little? Okay. I'm getting a little feedback. Maybe it's my hearing aid. Okay. Okay, Ms. Holman?
My name is Kathy Holman, and I am Jillian Holman's mother, and I too live in Glen Rock, Wyoming. Committee members, thank you for this opportunity to speak with you today. The past 2.5 years have been among the hardest I have ever experienced. It was shocking to me to realize that we are now nearing the point where 3 years of our lives have been consumed by things I thought only happened to other people. Not a family like ours, happily living out the American dream in a small rural town in Wyoming. During the year that my daughter and Preston were being stalked, we were constantly on edge. We feared for the physical and emotional safety of our daughter, as well as our 4 other children, and even ourselves. I watched my joyful, vibrant, and at times, admittedly sassy daughter turn into a teen who felt isolated, helpless, and scared. A girl who no longer felt comfortable attending her friends' sports games unless I attended them with her. Even after we identified our stalker, a 40-year-old woman named Marcy Smith who lives in our town, we remained fearful. At the recommendation of the local law enforcement and the prosecuting attorney, we enacted a family safety plan and remained publicly silent about what had been done to us. It was incredibly isolating. And our family sat helplessly while our character continued to be brought into question as our child stalker took our silence as an opportunity to continue to spread misinformation. But we stayed strong and focused on all the good work we could do when we could finally go public with our story. In March, after our plea hearing, we were finally able to share our story. I thought our name would be cleared and that we could return to the life we had known before this. I was wrong. Instead, I found myself constantly fighting to protect my child as Marcy pushed the boundaries and exploited the gray areas of our protection order over and over again. We found ourselves in court yet again in July of 2025. After a 4-hour protection order hearing, a judge ruled in our favor and issued a stricter protection order. Immediately after the trial, on our way out of the courthouse, one of Marcy's family members looked at us and told us, "You better sleep with one eye open because we're coming for you." Our protection order is simply a piece of paper and assumes that someone who has already broken the law will follow the order to stay away. Our family continues to be targeted, but we have slowly but surely, through faith and sheer willpower, refused to let that change who we are at our core. We have found a new normal. Yet I dread the day our protection order ends. Because of Wyoming's laws, our daughter's stalker can work in schools. With only misdemeanor charges, she can return to volunteering at the school where my other children attend, serve as an advisor, and join them on overnight trips. With our stalking laws as they are currently written, adults in Wyoming who have been found guilty of stalking a child would pass most background checks for coaching and teaching positions in this state. I believe that if our stalker had been convicted of a felony, our story over the last 1.5 years would be entirely different. We wouldn't have had to go back to court multiple times to fight for our daughter's safety. I can't help but feel that if Marcy Smith were in jail, my family and I would have felt safer sooner and been able to find our new normal quicker. I can't tell you how disturbing it is for me to know that it is perfectly legal for my daughter's stalker to own a firearm. In Converse County in 2024, there were 88 reported stalking victims. 5 of them were children. Keep in mind that 70% of stalking cases go unreported. This packet in my hand contains 36 statements from other victims of stalking. 34 of the victims are from Wyoming. They have heard our story and sent theirs to us, asking us to be their voice. I won't take the time to read them now, but I will happily send you a PDF so you can read them later. The overwhelming theme in these stories, it is fear, hopelessness, devastating mental health issues, and over, I read the statement, the police said they couldn't do anything to help us. House Bill 8 has been the focus of our family's work with you over the last year, but I strongly encourage you after this current legislative session is over to take a closer look at our stalking laws as a whole and how the victims of this crime are treated when they seek help. The first step in protecting Wyoming's youngest and most helpless stalking victims is to vote yes on House Bill 8 and make an adult stalking a minor a felony. but I am pleading with you, please do not stop there. Thank you.
Thank you, Ms. Holman. Committee, any questions for any of the witnesses? Okay, please share that PDF with us if you would. Thank you. Thank you so much. So it's quite the journey. Representative Webb.
Can I ask you here?
Commissioner, welcome.
Mr. Chairman, members of the committee, thank you for taking the time to listen to this very important topic.
Please identify yourself for the record.
My name is Robert Short. I'm a commissioner, a county commissioner in Commerce County, Wyoming. These beautiful people who've just testified in front of you represent the voices of those who have been abused in the past. Here in Wyoming, we take life seriously. We work diligently to protect life. Sometimes it seems we forget that life doesn't stop at birth. And some of our youngest and most vulnerable are left trapped in a system that gives their abusers the ability to continuously torment and terrorize their lives. I think it's imperative that we take a strong look at these things because we are charged with health, welfare, and the safety of our constituents. And House Bill 8 is a step in that direction. And I would please urge you to support this and continue moving forward with these laws that will help us make Wyoming a place where our kids want to stay. Thank you very much, and I'll stand for any questions, sir.
Thank you, Commissioner. Any questions for the Commissioner? I'm sure the family appreciates your support today.
Thank you, Mr. Chair.
Anyone else wishing to testify on House Bill 8? Good morning.
Good morning, Chairman, members of the committee. My name is Patricia McCoy. I'm from right here. Sorry about that, Chairman. My name is Patricia McCoy. I'm from right here in Laramie County, and I am here today on behalf of Moms for Liberty chapters throughout Wyoming. I'm speaking today in strong support of House Bill 8 relating to the stalking of minors. It does not create a new offense or expand the definition of stalking. Instead, it clarifies how existing law applies when an adult engages in stalking behavior towards a minor, while also recognizing the unique vulnerability of children and limited ability of parents to intervene once such conduct begins. This bill is narrowly tailored. It applies only to adult offenders and relies on the same legal standards and burden of proof thresholds already required to establish stalking. Judicial discretion due to due process protections and prosecutorial judgment remain fully intact. But by addressing the stalking of minors with the existing felony framework, this bill provides clarity and consistency without mandating outcomes diminishing the court's ability to consider the specific facts of each case. We believe House Bill 8 strikes a careful balance, reinforcing child protection while respecting parental rights, constitutional safeguards, and the legislature's responsibility to avoid unnecessary expansion of criminal statutes. For these reasons, we ask you to please support House Bill 8 and get it to the finish line. Thank you.
Appreciate you being here. Questions for the witness? Seeing none, thank you. Good morning. State your name for the record, speak into the microphone, and tell us what you'd like us to hear.
Good morning, Mr. Chairman, members of the committee. My name is Clark Fairbanks. I'm the director of the Wyoming Youth Service Association, which is a member organization of nonprofit youth service agencies across Wyoming. I stand today in support of House Bill 8. I appreciate the efforts you've taken during the interim to provide additional protections for children in Wyoming. The Wyoming Youth Service Association members see every day the impacts of abuse and stalking on our children. Last year, member agencies served nearly 12,000 children in Wyoming who were in crisis, needing emergency care, shelter, group home treatment, and psychiatric treatment for their abuse, neglect, and emerging mental health issues. So again, we believe that this is one step that can provide additional protections for children in Wyoming. and I urge your support. I'd stand for any questions that you might have.
Questions for witness? Just let me say thank you on behalf, of the committee for all that you and your member agencies do for the kids across Wyoming. We rely on those nonprofits tremendously. If the work that you all did were paid for directly and totally by government, they were all staffed by government employees, the burden would be tremendous. So thank you very much for the work that you do.
Thank you.
Anyone else? Mr. Thompson?
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And I just wanted to mention that our members have expressed some strong support for the changes in law in this bill. And I would like to just point out real quickly that, this is a punishment portion of it, and probably you would think doesn't change law enforcement's response, investigation, and prosecution side from the street level. But when you look at the laws surrounding misdemeanor arrests and how you can affect an arrest to stop action, by raising this penalty to a felony, it takes that question out of whether you can or can't arrest and the circumstances. So by turning this into a felony violation, an arrest can occur, and the situation can be handled in front of the court, and the danger to the victims at that time is at least suspended while that person is in that jail waiting for a court date. And I'd be happy to answer any questions if you have any, sir.
Thank you for being here. Questions for the witness? Thank you, Mr. Thompson. Anyone else wishing to testify on House Bill 8? Ms. Chambers, could I get you to come up? Wasn't going to let you escape day one. Good morning. Would you introduce yourself? And then I have a couple of questions.
Good morning. My name is Kara Chambers. I'm the Director of the Division of Victim Services with the Wyoming Attorney General's Office.
Could you describe for the committee, Ms. Chambers, what resources are available through your office for victims like we heard about this morning?
Absolutely. Thank you, Chairman. The Division of Victim Services has a couple different roles. I like to talk about two different sides of the house. The one side of our house is the victim assistance, by which we pass through state and federal funds to 57 different victim service providers across our state. There's multiple in every county that would work with all victims of crime, including the domestic violence, sexual assault programs. We also have 3 child advocacy programs across the state who would do forensic interviews for child victims. We also fund sexual assault nurse examiner programs, CASA programs. Again, victim advocacy housed in both law enforcement and prosecutors' offices, and again, the aforementioned nonprofit programs across our state. The other side of the house is my office also administers our state crime victims compensation program. And that is funding, again, through state surcharge, which are state criminal fines and fees, not general fund dollars, and federal VOCA, which is also criminal fines and fees dollars that go to assist victims of crime with any out-of-pocket medical, mental health, relocation, property taken as evidence funds. That's in statute. It's capped at 15,000 with a potential additional 10,000 for catastrophic instances. And beyond that, we also house within our office specific to children. We manage the statewide Safe to Tell program, which is a confidential tip line for students that they may reach out and seek assistance. It was originally born out of Columbine in Colorado for school violence, but has rapidly become one of the largest tips we get is suicide and suicidal ideation with young people across our state. And so that is a resource that we provide because we do see that nexus between victimization and taking of one's life.
Thank you. And is stalking one of the crimes that would be compensation would be available?
Chairman Wassett, absolutely. Stalking also happens to be one of the tips that we see among students. And so this bill is much needed, whether it's, an adults or other people in their lives. Stalking is absolutely compensable. The requirements for compensation is that a crime is reported to law enforcement and law enforcement believes a crime occurred. And that's the simple threshold. In instances of stalking, mental health is available not just for the victims in these cases, but they're what we call associated victims, which would be the parents who didn't directly become victims of the crime, but are obviously associated by nature of what you just saw testified by the Holmans. I mean, they were obviously, their entire family was affected. So we also assist with associated victims on a primary victims claim.
Thank you. I always
Yeah.
enjoy the opportunity to learn more about your office. Questions? from the
Appreciate
committee?
the opportunity.
Thank you so
Right,
much.
thank you.
Ms. Butler? Day one. Now everybody's looking around and says, you gonna call on me next?
Like a law school class.
Please introduce yourself, and I have a couple of questions.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch.
Thank you for being here. I know you weren't expecting to testify. We heard some testimony about a bond reconsideration hearing that was done ex parte, where apparently only one of the parties were present, and the victim's family testified that they weren't even aware that the modifications had been granted. I know that's not completely your domain, but you're the best in the room to answer this question. So is that common for a judge to reconsider a bond condition without both parties being informed and present?
Mr. Chairman, so I think maybe a little bit of clarification. First of all, I can't speak specifically to any case, so just to keep that in mind. But what would generally happen is because the bond amendment or the change in the bond is part of the criminal case as opposed to the civil protection order case, right? So what you would have is, and again, I can't speak to this case, but what would generally happen is both parties, which would be the state of Wyoming, whoever's prosecuting the case, and the defendant would know of that bond amendment or the request to change the bond. So those two parties would generally be apprised of a motion, and then if there was a hearing, both parties would be present. And again, that would be the state and the defendant. Any victims as a part of that criminal action would be not a party to the case, right? So it's possible that they didn't know about it. I would say generally what would happen in most cases is the prosecutor in that case would contact the victim and talk to the victim about, you know, their thoughts or feelings about that bond amendment.
So is that part of the Victims' Bill of Rights in Wyoming that notification should have been made by a prosecutor in this case?
Mr. Chairman, I am not, I believe so, but Ms. Chambers would know better. She has an intimate knowledge of that statutory section that I probably do not have.
Thank you for making the distinction between the civil and the criminal, and that in the criminal, the parties are the state and the defendant, not the victims and the defendant. Thank you for that.
Mr. Chairman, yes, that's correct.
Questions? All right, thank you so much.
You're welcome.
Anyone else wishing to testify? I don't have a good question for Director Schmidt back there, so I'll let you off the hook today, okay? All right, with that, I'll close public comment. Is there anybody on Zoom? Ms. Hackle. Nice to have a willing witness to testify. Ms. Hackle, are you there? You're coming in, okay.
What? I feel like a bad telephone commercial. Now can you hear me?
I can hear you, but I can't see you. But please introduce yourself and let us know what you want us to know.
My name is Sylvia Hackle. I'm the Laramie County District Attorney. I'm appearing on behalf of the Wyoming County and Prosecuting Attorneys Association. And I apologize. Wait, I see something I think I can turn on, maybe, so that you can see me. No, it's not working. My apologies. I'm not technologically brilliant. The association strongly supports this bill. There is nothing I can say that would be more impactful than the testimony you heard at the beginning of your meeting. It is absolutely correct. Stalking of minors is absolutely devastating. And having the ability to charge this as a felony will mean a world of difference to those who are impacted by this offense. So we encourage you, as a previous speaker said, to carry this one across the finish line. Thank you.
Thank you. District Attorney, we have to use the whole term, District Attorney, DA Hackle, appreciate you being here this morning. Could you comment on the bond modification question? I don't know if you heard my question to Ms. Butler earlier.
I did. And I believe her response, I agree with completely. There are two separate proceedings. There's the criminal proceeding and then the civil one, which in this case involved a protection order. Ideally, in the criminal case, even though, and this is one of the reasons we have a Victims' Bill of Rights, traditionally, victims are not parties to a criminal offense, which, as a citizen, you think, wait, they're the ones who are most impacted by this. How can they not be parties? But the state is the prosecuting entity, and then we have the defendant. So what victims advocates have brought to bear, and in our office we have too, and also our law enforcement have victim advocates, is that they contact the victims when settings like this are held and say there will be a bond modification setting. I do not mean to criticize the Converse County prosecutor. I don't know why or how that hearing came about without notification to the victims, but they should be notified. My personal opinion is they should at the very least be allowed to give input to the prosecutor, who should then at least represent that position to the court. If this were a felony, I can assure you that the judge would have been far less likely to modify bond conditions. So that's the reason for making it a felony, but I can't speak to the specific incident, but I agree with what you heard with respect to the various roles involved.
Thank you, very helpful. Committee, any questions for District Attorney Hackle? District Attorney, I just want to say thank you for being here. Too often, we don't have prosecutors available to give us some insight, and very much appreciate it when you're available to chime in.
Well, and I apologize, Mr. Chairman, for not being there in person. I just had knee replacement surgery, and some days traversing the long distances through the state capitol can be a challenge. But I will, having had this experience with the audio and the video, do my best to be personally present throughout the rest of the session. Thank you.
We appreciate that. Heal up quickly. All right. With that, I'm going to close public testimony. There's nobody else on Zoom. We're going to close public testimony. Committee, what's your preference? Representative Filer moves the bill, second by Chestic. Any discussion or amendments to the bill? Representative Filer? Anything? It's one whole sentence. All right. Any discussion on the bill? Any comments from the Representative Ling?
Thank you, Mr. Chairman. I just want to thank this committee and this family for coming forward and telling your story publicly. I know that that's not always easy, and there's always some naysayers that go with that. So thank you for bearing that burden as well. And thank you to the committee for taking this up in the interim.
Others? Okay. Call the roll on House Bill 8.
This is a roll call vote on House Bill 8. Representative Brady.
Use your microphone.
This is a roll call vote on House Bill 8. Representative Brady.
Aye.
Representative Bratton.
Aye.
Representative Chestek.
Aye.
Representative Filer.
Aye.
Representative Kelly.
Excuse me.
Representative Lean.
Aye.
Representative Singh.
Aye.
Representative Webb.
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused.
I think with that, the bill will move to Committee of the Whole, which is the part of our process where will present the bill on the floor. I will present the bill on behalf of the committee to the other members of the body. They will then have opportunities to ask questions and comment and also to amend the bill. If it passes committee of the whole, then it goes on to second and third reading. And hopefully then we'll pass over to the Senate side and this whole process repeats itself. So hopefully all of you with your impactful testimony will be available to participate in Senate processes when those days come. Thank you. Which brings us to House Bill 9. Committee, this too is a joint Judiciary Committee bill that was considered over the interim, so it's not unfamiliar to everyone. It's a little more lengthy than the previous bill. Creating a new crime is always a longer process than simply amending an existing crime. Is there anyone in the room wishing to testify on House Bill 9? Please come forward. Yeah, make sure your microphone's on green, speak into the microphone, identify yourself and where you're from, and tell us what you'd like us to hear.
Thank you, Chairman and Committee. My name is Brandy Sorensen. I am from Converse County, and I'm here for my son, Preston Sorensen, who is with us today. And I want to tell you that stalking and grooming are two separate issues that need to be addressed separately. What happened in my son's case, I'm going to back up. I know that you've heard from me before. In my son's case, I believe the grooming led to stalking. When my son's perpetrator was caught by me seeing that she was talking to my son about his underwear on I got on a parent app, and I addressed her personally. It wasn't asking to see him in his underwear. She was asking for her daughter, who happened to be my son's ex-girlfriend. And I thought that our values were just completely different. And there's a whole lot that goes into that, but I addressed it and it didn't stop. She went into stalking and continued grooming. But on the outside, she seemed like a great supportive member of the community. And so grooming, it's important to know that grooming happens before other physical crimes that are on the books. It's been a long time. So another quick recap is that law enforcement and prosecutors told me that there was nothing they could do about her grooming behaviors, even after the stalking case. And I went back through and found more evidence of her grooming my son. I appreciate that the work that you've done so far, and I encourage you to finish this. We've seen the word grooming used in everyday society to mean different things. I want to be very clear in the context of House Bill 9. This word is used for one specific purpose: to prevent the sexual abuse, exploitation, and trafficking of Wyoming's children. Grooming happens before physical acts and pornography. In your packets, you'll find reputable sources and reports that break down the sexual grooming model, the 6 stages of predators used to groom children, and the one right before abuse is desensitization, including sexual conversations. You will also see that how this process damages a child's brain, even if no sexual contact has been had. And you'll see that my son's case is not an anomaly. Grooming is so much more than just creepy behavior, and it's not well-meaning people trying to help educate children in need. In my son's case, his perpetrator said things like, "Did you have a boner? Send my daughter a picture of you in your special underwear." She asked him if someone was good, implying in bed. She joked about how she made money having stacks of dollar bills. She joked about putting lingerie in her daughter's truck and saying it was from him. She asked if someone was a MILF, which means a mom you would like to have sex with. After she was caught, she moved on to putting bumper stickers or magnets on other teen boys' trucks. Things like honk if you're horny and addicted to porn. She was in a Snapchat group with these teenage boys. After she was caught, she reportedly said something to the effect of, "Sorry guys, some people can't take a joke." This is no joke. This is a classic grooming of a sexual predator before she crosses into laws that are already on the books. I've been questioned by both senators and representatives that surely we have laws that cover this, which I'm no lawyer, but I've done a lot of research and reading of the definitions of statutes under current Wyoming law, and none that I can find say that what happened to my son was a crime. I'll go through most of these that I've been addressed with. Soliciting doesn't fit because she never asked my son for a sexual act of any kind. Sexual abuse of a minor, in any stage, it requires physical intrusion or sexual contact. Trafficking requires physical. Sexual exploitation of a minor. This one, there are a few ways that people can be charged with this, and most of it deals with child pornography of sexual acts happening and physically using a minor for a sexual act or conduct. The only part of that law that even comes close to my son's case is the phrase lascivious exhibition of genitals or pubic area by either enticing it or distributing the photos or videos of it. What's lascivious? The Webster definition is it was not defined in the law. So I looked up the Webster definition and it says it's being filled with or showing sexual desire, being lewd and lustful. So if a kid is manipulated into taking a selfie in his underwear, is that lewd enough? Does it show sexual desire or lust? What about other underwear selfies? How can you tell the difference? That is the only thing this woman did that might fit under current law. But imagine trying to prove that beyond a reasonable doubt in front of people to a jury. What if she never suggested that picture? Are the other things that she said and did not enough that she should be free to move on to those other victims? House Bill 9 closes this gap. It includes the depiction or observation of a child in a state of undress for the purpose of arousing desire or humiliating the child. I think with all the other context in the case, they could prove that beyond a reasonable doubt. What makes this bill work is how it pairs the definition of grooming with clear intent. I encourage you to read those two parts of the bill together. It protects well-meaning people while closing the legal loophole that currently lets predators walk free just because they were caught before the physical abuse started. In my son's case, she had a clear pattern of behavior. She used her position of authority to build a secretive, sexualized relationship. Under current laws, she walked away. Under House Bill 9, she would be held accountable, and so would others just like her. House Bill 9 also requires sex offender registration, which limits an offender's access to working with children and prevents more crimes. I would like to say that also that makes it more available to the public. Felony comes up in a background check, but a sexual offender is more available to the public. I want to know who's my kid's neighbor or my kid's girlfriend's mom. I do think that the punishment of up to life are extreme for grooming. I would suggest making a simple felony of up to 10 years and a fine of $10,000, leaving the leeway up to the judge to decide based on the severity of the case. I'm asking you to pass House Bill 9 and ensure that no other Wyoming parent has to sit where I am, knowing what happened to my child and that the perpetrator moved on to other victims, and maybe worse, when a different mom sits and find out that your kid wasn't the first victim, but that the law says it doesn't count. This isn't about politics. This isn't about what my families may or may not have done and are in prison for. This is about the safety, prevention, and protection of Wyoming children. And I would be happy to stand for any questions.
Thank you.
Thank you.
Questions, committee? Mr. Co-Chair, Vice Chair.
Thank you, Mr. Chairman. And thank you so much for what you've had to share with us today. This is such an important topic and I want to make sure that we get this right. How, in your opinion, how does this bill interact with the important conversations that parents need to have and are responsible, ought to be responsible for having? That's such a precious relationship, and that relationship comes with certain responsibilities to talk about the birds and the bees or difficult situations, is how anatomy works. And so do you think this bill prevents parents from having those conversations?
Ms. Orton.
Thank you, Chairman. Thank you, Representative. No, I think that it is a great topic to be had. And the parents still have that right, responsibility, and opportunities to talk to their kids about that. I actually do come from a law enforcement family, so I had those talks. I had those restrictions on phones. I had those things. And number one, I would just like to say that you can do all the right things, but you can't always prevent everything. But I am glad that I had those conversations with my son. Even though we've had those conversations and we still, grooming happens very slightly, very manipulative, very sneakily. Even now, my son is just barely comprehending and realizing things that she said or did that was very uncomfortable, but she's in a position of authority. She's his girlfriend's mom at the time. And even though we had had all those conversations, it didn't cross into asking, hey, masturbate in front of me or whatever weird thing, you know. That's why groomers start with things like this. And I think that preventing it and talking about it is great, but I prevented it. I addressed it when it happened, and she continued to move on to other things.
Mr. Vice Chair, anything further? Representative Chesty.
Thank you, Mr. Chairman, and thank you for your testimony. I'm very interested to hear what's going on here, and I'm very concerned about what happened to your son. It was horrible. I appreciate your being willing to testify in very difficult circumstances. I have a concern, a question about whether the definition of grooming is a little bit too broad. And I want to get your reaction to this, my concern. And my concern is that it might capture legitimate sex education classes in high school. And here's my thinking. It's the definition on page 2 of the bill, line 7, grooming means behavior that seeks to prepare a minor to engage in sexual conduct. There's other inclusions, but that's pretty broad. Behavior that seeks to prepare a minor to engage in sexual conduct, which is what sex education does, right?
Mhm.
So would you have any concerns if we amended it to have an exclusion that legitimate sex education classes are excluded from the definition of grooming? Would that be a problem for you?
No, that absolutely. Oh, sorry. Thank you, Chairman. Thank you, Representative. No, I don't believe that would be a problem at all. I think that's wonderful. Again, I'm not a lawyer, but just based on what I know through our case, the stalking law, if you look, it has the definitions and then the intent in a separate part. And that's where I was saying that definition is just a definition, but the proving of the elements of the crime, as I read it, not a lawyer, does have that. They have to groom with the intent to, anyways, it's in there. I can't find it right this second, but they have to have the intent to exploit a position of authority to develop an intimate or secretive relationship with a minor. So in my brain, that's how I think that it saves well-meaning people. But if you want to put in things like that specific, I think that's wonderful.
Further questions? Thank you. Seeing none. Thank you. Appreciate your testimony.
Thank you.
Anyone else wishing to testify on House Bill 9? Apparently it was a good idea to put these two bills on the same agenda. Mr. Thompson.
Mr. Chairman, my name is Alan Thompson with Wascop Chiefs and Sheriffs Association. And I would just like to, I guess, echo the comments from the previous speaker about the application of the law, because from a law enforcement perspective, I think that she summarized that very well. There are a lot of laws out there that apply to these types of activities, but this helps fill a gap that might occur, as you heard from the testimony earlier this morning, and gives law enforcement another tool to work to prevent the physical abuse of children related to these types of crimes. And our membership has been in support of this. We've talked about a lot about the language and so forth. And I mean, I think that this is a good question for the prosecutors or the lawyers on the questions that have been raised so far in the application of the law, and if it reaches too far, because at the end of the day, you still have officer and prosecutorial discretion. You still have the judge and the jury before a conviction occurs. So there's 4 levels of review of this before someone is actually convicted of it. And that discretion can apply even if the bill might reach too far. I think the intent of the bill is very clear. It's looking to rein in those acts by people that are preparing for or receiving gratification from the non-physical contact. And it's just, I think, a good tool to help prevent children from that physical attack.
Thank you, Mr. Thompson. Questions for Mr. Thompson? All right, thank you very much.
Mr. Chairman, members of the committee, Clark Fairbanks with the Wyoming Youth Service Association. Again, standing in support of this bill, providing our legal system more tools in protecting children. And again, just to give you some perspective on this from across the state, as I said, the nonprofit agencies that we represent last year served 12,000 children, Wyoming children. And in a snapshot data we do each year to track the trends and information of the presenting issues to children that come into our crisis shelters, group homes, counseling services, 34% of them last year reported being sexually abused. That's a significant number of our children that need our protection and need these services. And so I think the challenge is when this happens, that child and that family feel like they are isolated, that they are alone in their experience, and they're not. And so that's just one of the perspectives I wanted to share with you today as you consider this. And I appreciate your time and would stand for any questions.
Representative Lane.
Thank you, Mr. Chairman. Thank you for joining us today. My question would be, when you have a child that's come in and that has suffered some of these sex abuse acts, could you tell us what kind of services they then are tied to through your organization?
Sir.
Mr. Chairman, Representative Lean, there are 17 member agencies, the nonprofit youth service agencies representing Wyoming Youth Service Association, and those services range from forensic interviewing to counseling services that are offered to the family, to the child. Emergency shelter, sometimes there's a safety issue or law enforcement can place a child or child protection, but most of the children and families access those services voluntarily. They need that safety, could be suicide ideation, and they need 24-hour awake care to make sure that they're safe until they can get additional services, all the way through residential treatment and psychiatric residential treatment for assessment and stabilization. So, and just counseling services and family therapy and parenting classes, just as, I mean, it's a pretty broad range of services that are provided. And those are the member agencies. There's 14 communities where those services are at. And they provide regional services trying to cover all of Wyoming. And that's our goal and our purpose. Thank you.
Follow-up, further questions? Very good. Thank you again for being here this morning. Ms. Chambers.
Thank you, Chairman. Kara Chambers, Division of Victim Services. I just wanted to mention one thing for the benefit of the committee. This bill, by adding a sex offender registry, also opens up the opportunity for individuals who move to our state who might have been required to register but haven't been required to register because we didn't have similar laws on our books. So this is not just protecting from the offenders that are here, but from Wyoming becoming a safe haven for those who can come here and not have to register because we didn't have similar language on the books. For those of you who've been around, we had testimony from a victim several years ago whose offender in Maine was required to register under similar language that didn't previously exist in our state and came here so that he wouldn't have to register. He had groomed her as a youth camp advisor, if I recall. And in Maine, there was similar language. And so I really do think that this fills an important loophole, not just for the crimes that are occurring here, but for those who might seek to evade registration in other states.
Thank you for that. Representative Chesky.
Thank you, Mr. Chairman. Ms. Chambers, thank you for being here. And excuse, this is a dumb question, and coming from a lawyer, I should know this, and I don't. And that is the 10-year felony. Is 10 years the minimum penalty for a felony, or can there be a felony with less than 10-year jail sentence?
Ms. Chambers.
Chairman Wassett, Representative Chesick, I believe there is a range. It's all over the place, but I'm going to defer to what you choose to impose.
Thank you.
It's a policy question.
Further questions? Thank you for being here.
Thank you.
Others wishing to testify this morning? Remember, speak into the microphone, identify yourself again, and tell us what you want to know about this bill.
I moved it ahead of time this time. Thank you, Chairman. Before I put my Moms for Liberty hat on, my name is Patricia McCoy, and I am here from Laramie County. I spent the last 2 years speaking to you guys in committees and out of committees regarding what happened to my daughter. I fought for her for 2 years to help with the situation of her grooming. You guys all know the details of that. You all know we got zero help. I was on my own. This would have greatly helped in our situation. I can provide an update today on that situation with that individual who left our state. She was since arrested in Colorado for the same exact thing. So I wish we could have done it ourselves. That would have made me much happier as a mother. But we dropped the ball there. So I'm gonna switch from my mom hat to my Moms for Liberty hat, if that's okay, Chairman. Speaking for all of our chapters across the state today, we are in strong support of House Bill 9. It does address a clear and serious gap in our laws in this state. It defines the grooming behaviors more detailed that are used to manipulate our children. They are innocent and they should remain that way. It focuses on deliberate, intentional conduct by adults who seek to build trust, exert influence, or create secrecy, which we have seen from multiple stories being shared. These behaviors often occur through electronic communication, indirect contact, positions of authority, and they are frequently hidden from parents. Sorry, I still have my mom hat on a little bit. I apologize, Chairman. House Bill 9 is clearly structured and very carefully done. It's been worked on for a very long time for many, many people. It applies to adults, it requires intent, and it relies on established legal standards and the burden of proof. Judicial discretion remains in place, allowing each case to be evaluated on its specific facts. This bill strengthens the ability of the law to protect children at an earlier stage, while respecting parental rights, due process, and constitutional limits. For these reasons, we respectfully ask the committee to support House Bill 9 through this session. Thank you.
Thank you. We appreciate both parts of your testimony. Any questions? Thank you for being here. Identify yourself, sir, and tell us what you'd like us to hear about House Bill 9.
Good morning, and thank you, Chairman Washington and committee members. My name is Steve Amelia from Cheyenne, Wyoming here, and I am in support of this bill. I would like to address this bill in a sort of a different manner. I know that groomers have a lot of material out there, and there is a lot of material that is available to them in our libraries. Having 30 years in public health and in Houston, Texas, where they have the same situations as we do, I gave multiple presentations to hundreds of students, and I've seen it up here, and having worked for the Wyoming State Department of Health in public health, I know that the mentality of public health and other agencies have a tendency to make it easier for groomers, because when I would give presentations on sexually transmitted diseases, HIV, AIDS, and other types of risk behaviors, the mentality was that, oh, abstinence is just a fallacy. It's sort of a myth. We need to teach students all kinds of different types of sexual behaviors, which made it easier for groomers to lure children in. And when I would listen to these other presentations, I'm going, everything they're doing is outside the realm and the scope of acceptable behavior. I've just taken 4 courses on safe environments for children. And when I see what some public health agencies are doing, not just in Wyoming, but also when I was down in Houston, all of it, for the most part, falls outside the realm of acceptable behavior of keeping children safe. When I would give presentations to children, junior and senior high, I would tell them that you don't have to do any of this stuff. There are agencies that want you to do these types of behaviors because they can then write more grants, and the people had the agenda that, hey, any kind of sex is fine, don't worry about it. And there was one particular book that I'll bring up. They said sexually transmitted diseases, quote, it's no biggie. That is false lie. When you say sexually transmitted diseases are no biggie, it's no problem, no big deal, that really sets children up saying, oh, I can have sex, and if I have a disease, no problem. That makes it easier for groomers to say, you don't have to worry about all these consequences. And when it came to pregnancy, again, a lot of material that was given out to students during presentations, no matter what was Planned Parenthood, which also trained me in Houston. It gave a more of a easy pass for groomers to move in. And the mentality of our society, specifically here in Wyoming, in Cheyenne, there are 2 adult novelty and lingerie shops. I've been in both of them. One of them I've been in multiple times. I've been on their website. And the mentality is, even to sadomasochism, bondage, and torture devices, which is supposed to be pretty okay, that mentality permeates our society. And it's like, we adults are going to have this mentality and then say, oh, we can protect children from groomers by promoting and supporting, or at least turning a blind eye to this type of mentality, which permeates our society, permeates public health. And I was in public health in this Wyoming Department of Health here for 20 years. And I'm going, this bill is really important. We need to cut this down. There's a lot of sexual behaviors out there that are depraved, that are seen as, yeah, it's okay, no problem. So I would ask you to support this bill, and thank you for the time.
Thank you for coming down today. Appreciate that. Questions? Don't see any. District Attorney Hackle still online if you want to testify on 9. Thank you.
All right, can you hear me now?
I can hear you now.
Okay, I had my camera on.
I
I'm
can
not.
see you too. Yes,
You see me?
I can see you.
Well, how exciting for you. In all seriousness, Mr. Chairman, my name is Sylvia Hackle. I'm the district attorney here in Laramie County, and I am appearing here today on behalf of the Wyoming County and Prosecuting Attorneys Association, which has taken a strong stand in favor of this bill. Several points were raised during the earlier testimony, to which I would like to add additional information. sort of starting at the end, a question was asked about the definition between a felony and a misdemeanor. It's in Wyoming statute, section 6-10-101. A misdemeanor is anything up to 1 year. A felony is anything over 1 year. So when you make an offense a felony, you're not, if you just said this crime is a felony, that would theoretically give a judge authority to sentence the perpetrator to anything above 1 year. But you have placed some maximum sentences in this bill, and that's fine. Almost every statute, criminal statute in Wyoming, has either a top offense, like a lot of our theft offenses, it's no more than 10 years. Or some even have bottom numbers, 5 to 25. So the way that you have articulated the penalties for the felony in this bill fits well within the structure of Wyoming criminal law. The definition of grooming has been discussed, and particularly with respect to whether sex education might come under scrutiny. And as the gentleman from Wascott pointed out, there are multiple layers in any criminal case. Law enforcement has discretion, and most importantly, in this context, the prosecutor has discretion. So if a case were brought to me and somebody, first of all, I don't think if somebody reported to local law enforcement that, oh my heavens, there was this sex education film that crossed the line into grooming, I think it would be evaluated carefully by law enforcement before it would ever be brought to my office. And if it ever made it to my office, we would look at it very carefully. And so there's a level of discretion and review there. So just because somebody says they're uncomfortable doesn't make it grooming. I have to tell you, in my experience as a prosecutor, I happened to have 2 cases at once many years ago. Both were appeals. I was representing the state on appeal in front of the Wyoming Supreme Court. Both involved sexual assault. But in reading the lengthy trial transcripts, one of the perpetrators was a teacher. The other one was a physician. And in reading, when I sat down and I read these lengthy trial transcripts, one right after the other because of the way the cases were timed, it was chilling. It was like reading a bad novel as you saw the behavior of the perpetrator lead the victims down certain paths, repeated in victim after victim after victim. And both cases, well, the public educator case involved only minors. The physician case involved minors and adults. So grooming is out there. Now, the cases to which I refer involved cases that resulted in actual physical sexual assault. But grooming would have been appropriate, and more importantly, to read it in that context. I mean, I was not an inexperienced lawyer at the time I had those cases, but it was chilling. It was just chilling. I don't know any other way to phrase it. So my fellow prosecutors and I support this bill. You've heard this said before. It's another tool in our toolbox. And we realize you may want to make some, tweaks to it as it goes through the system. That is certainly a policy decision in your purview, but making it a felony and the sex offender registration, for all the reasons testified to before you today, is important. So thank you for your time and your consideration and your patience with my technological inabilities.
District Attorney, do appreciate you being here. Appreciate the stories and the experience that you bring. Questions for the District Attorney? Representative Chestick?
Thank you, Mr. Chairman, and thank you for being here, DA Hackle. Just to kind of clarify some of the testimony we've heard before, several people have testified that the conduct that we heard about from the victim here and the victim's mother is not captured by current law. Would you? And I think Weisskopf agreed with that statement. Would you agree that there is a gap here that there was no way to charge the perpetrator of the crime?
District Attorney?
Mr. Chairman, Representative Chesnick, that's absolutely correct. So often, this kind of behavior, law enforcement and prosecutors aren't comfortable with it, but a lot of offenses, unless there's been something physical that's occurred, I mean, really outright physical, that clearly fits within another definition like sexual assault, it's what we call an inchoate offense perhaps, and you can't get to it. I can't tell you how often victims come in and say, but I'm uncomfortable in this person's presence, or he threatened me. And it's amazing. You would think these things would be in the statutes and they're not all. So yes, there's a gap in the statute. And yes, this will plug one of those important gaps.
Mr. Vice Chair.
Thank you, Mr. Chairman, and thank you, DA, for being here with us today. So if we look on page 6, line 8, it describes a felony offense, against a victim who's under the age of 12. And it says that it's a felony punishable by imprisonment for not less than 25 years. And so as we discuss the nuances and the consequences for this, maybe this is good, maybe it's not strict enough, but can you tell us the actual cost of housing a felon for, say, a day or a year?
District Attorney.
Mr. Chairman, Representative Singh, I cannot, and I do know here at our local jail, I believe when the city houses a city prisoner, they pay I think it's like $150 a day. And I have heard in the past that a year at the penitentiary is like 15 to 20,000, but please don't hold me to those numbers, because I don't actually know. I will tell you with respect to a 25-year minimum, it's one of the highest minimums, if not the highest minimum in state statute. Second degree murder, for example, is 20 to life. So I think judges might be uncomfortable with a 25-year minimum. I know that a minimum that's that high, as a prosecutor, if I've got somebody that wants to plead guilty, is willing to accept the consequences of their conduct, and I say, well, but you're going away for 25 years, I think it might limit our ability somewhat to get those guilty pleas. Juries can't consider sentence, so it might not impact jury verdicts. But I'm not saying the 25 years is too high, but I'm letting you know that it's one of the, if not the highest minimum sentences that I've seen in state law.
District Attorney, when you have a minimum sentence in incarceration time, is probation still available to a judge?
Mr. Chairman, yes, Wyoming Supreme Court decisions over the years have stated that even with a minimum sentence, a judge must consider probation. Now, in most of those cases where there is a minimum sentence articulated in a statute, the judge will consider probation and then say, because of the nature of this offense, the nature of this offender, and what state law says, I do not find probation to be appropriate, and then a sentence of years will be imposed. I think I should add to that it is possible for someone with a minimum sentence to have their sentence, while they are still serving it, be commuted. The Board of Parole does that, and it's not like they say, oh, you're out of prison. They might take a 25-year sentence, say somebody got 25 to 30 years under the statute. And after the person's been in the penitentiary for a number of years, they might commute it to 20 years or 15. So those sorts of adjustments to sentences happen. And again, the Department of Corrections and the Board of Parole are a completely separate executive function from my prosecutorial function. But I do know that contrary to what many people believe and many people wish, a sentence of X number of years is not always a sentence of X number of years. The majority of people in the penitentiary are eventually released. And that's a hard concept to convey, particularly to victims. But that, again, the selection of the 25-year minimum is a policy decision for you.
Did you have a follow-up, Vice Chair?
Thank you, Mr. Chairman. And Representative Bratton pointed out to me that on our fiscal note, it says $45,625 a year per inmate.
Thank you for sharing that. Any further questions for District Attorney? Seeing none, nice to see you, and I'm sure we'll see each other again over the course of the session.
Thank you, Mr. Chairman.
Representative Brown. Glad you're here.
Thank you, Mr. Chairman. I appreciate your time and your opportunity to speak on behalf of this bill. Landon Brown, Representative House District 9 here in Cheyenne, Wyoming, and appreciate, and I also feel like she kind of stole my thunder. The DA just brought up a few of the points that I was a little concerned about personally on this particular bill. You know, there's been a lot of discussion over this bill over the past interim. Watched it very closely, watched the news articles, watched you guys deliberate on a pretty regular basis. Remember this bill coming through last year, supported the bill as it came through last year. And I think you guys did some good work. However, I think that there's a few areas that need to be tightened up and cleaned up. And my biggest concern, and the reason why I voted against introduction on this bill, be very clear about this, is when we have tried in the past to amend bills that are very close and dear to individuals, we have been pushed back against very heavily when we're trying to make a bill better. And I did not see that this was an opportunity where I would be able to bring a bill forward or an amendment forward and get some of these things corrected. That's why I'm hoping that we can do this here in committee, where we actually have a chance to work this bill and have an honest discussion about it. So first thing that I actually have a question on, I wish I would have been able to get up here before the DA. I do believe that section B 1 and 2, and I apologize, I believe it's on page 4, if I remember correctly. Yeah, it starts on page 4 and goes into B1 and 2. I believe there's a little bit of confliction with the way that that actually is worded and how that actually goes into how prosecutorial, you know, somebody in the prosecutorial world would actually be able to handle this. So starts out with they're 17 years of age or older and not less than 4 years older than the minor. And then purposely and knowingly engages to, but then if you skip down to subsection B in that same area, it says coerce or entice a minor under 16 years of age to meet in person. Well, you have somebody who's 17, but is less than 4 years, but they are under 16. That leaves a gray area of the ability to actually press charges. And so I don't know. I didn't have a chance to sit down and discuss this with attorneys. I will tell you, I have, I don't know if it's something that we can actually fix in here or if I need to talk with one of the attorneys to try to bring a floor amendment. But I do think that that's one area that I think needs to be cleaned up and maybe just made more clear of what we're actually trying to accomplish there. The other portion of this that I have the biggest issue with is what the DA finished off with, judicial discretion. When you go back and you look at 62316, which is sexual abuse of a minor in the 3rd degree, which is something very similar to what we're discussing here. Their sentencing in that right now is a person convicted underneath subsection A of this is subject to imprisonment for not more than 15 years. So the way that this bill is currently written, we are actually setting a minimum standard that says grooming is now more damaging and may or may not be, I'm not here to debate that, but is more damaging than the actual sexual assault of a child. We have given judicial discretion at 15 years, up to 15 years, and we set the minimum standard in this bill at 25 years. That takes a lot of judicial discretion away. The second thing that I would say in the judicial discretion actually comes down to the prosecution on this, and the DA mentioned this. When you start having these types of prosecutions moving forward, you do have the opportunity to arrange for these plea deals that come in. You have an opportunity here that at 25 years, as she just stated, somebody's going to flicker away from that and say, well, I think I have a better chance at taking this to trial and going to trial and finding that one juror that may not agree with this and have a hung jury and go through that entire process. That's a very real circumstance. Whereas if you put a ceiling and you give that judicial discretion available to the prosecution, you actually bring in a lot more opportunity for these people to be held accountable for their actions and not go through a jury trial. The other thing on here is new law states that we have in subsection D, a person who commits this grooming of a minor for sexual offense against a minor who is younger than 16 shall be guilty of a felony of not less than 4 years and not to exceed $10,000. I think this goes back into that confliction that I talked about in subsection B, whereas if you have somebody that's in that gray area of the offender, the perpetrator, potential perpetrator is 17 years old, but their girlfriend or boyfriend was 16 or 15, you have that falling of where does that actually fit? Does the prosecution have to prosecute and does the judge have to look at that and say, well, this person was underneath 16 years of age, so I applied this? Or do they get off because we have that gray area of 17 years old with less than 4 years? Mr. Chairman, I appreciate the time. I don't want to take much more of your time on this. These were the biggest reasons why I voted against introduction of this bill. I think this is a very, very important topic, but I will make it very clear that in the past, when we have had bills like this that are very near and dear to people's hearts, it is nearly impossible to fix out on the floor. I will not cast a vote for a bill that I don't think is capable of being fixed. I could have very easily stood up yesterday and when I saw that it was going to pass and voted aye to bring that in. I chose not to because I think the construction of this bill as it stands, and if it were to move through the way that it is not good law. We need to do better on writing the laws that are going to do this. I don't want to create an ambiguous situation where prosecution is not able to prosecute because of the ambiguities that we wrote. And I also don't want to take away the judicial discretion that our judges have underneath the other portions of law. The last thing that I will say is I do believe that underneath 62316 and 62315, we have very similar definitions, and I believe that it is a little bit, I don't know how a prosecutor would actually go look at this, but when you actually start talking about our definitions in here, we actually talk about penetration of the vagina or the rectum. That is sexual assault. That is already laid out. So I don't know which crime they would be charged with. Does this give the prosecution multiple arrows in the quiver to go after that individual? Or do they have to be charged with both? I think those are things that this committee, as you look at, you can't just look at the bill that we have sitting right in front of us. We have to read this in connection with everything else that's there. And with that, Mr. Chairman, I appreciate your time and I'll stand for any questions the committee may have.
Thank you, Representative. Any questions? I think you made some good points. Appreciate it. Anyone else wishing to testify on this? Nobody else online? Okay, I'm going to close public comment. Committee, what's your pleasure? Moved by the Vice Chair, second by Representative Webb. Let's go through and look at amendments. Then we'll take comments. So, page 1, any amendments on page 1? Any amendments on page 2? Representative Chesty.
Thank you, Mr. Chairman. I'm not sure if my amendment goes on page 2 or someplace else, but it's implicated by the definition of grooming. Some of the question I asked earlier, I do think that the definition of grooming is overbroad. Grooming means behavior that seeks to prepare a minor to engage in sexual conduct. The testimony was that it's not intended to be, that sex education classes are not intended to be covered. And the thought was that on page 5, the definition of the crime, the elements of the crime include purposely or knowingly engages in blah, 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 C. On line 12, page 5, line 12, distribute or facilitate access to sexually explicit material, which would be material that you would have to use in sex education classes. So I don't think this saves the sex education teacher. So I do believe that somewhere, maybe on page 2, maybe somewhere else, maybe on page 5, we need to include, and this is at this point just a conceptual amendment because I'm not sure where it goes or how to word it. But we need to have some kind of an exception to exclude bona fide sex education classes. So that sex education teachers, whether in schools or churches or wherever a bona fide sex education class is occurring, is not meant to be captured in this statute. And I did hear the testimony about how some sex education teachers might have ill intent, and that's why the wording of this amendment is going to be difficult, because we do want to make sure that somebody who is using that class for nefarious purposes should still be captured by this bill. But we do need to protect the bona fide sex education teachers, whether we do that on page 2 or on page 5. I'm not sure how to do that. So I guess my motion is I would move to have a conceptual amendment someplace, wherever we think it's appropriate, to protect bona fide sex education classes.
Thank you, Representative. Conceptual amendments are a little hard in committee. It's one thing during the interim to offer a conceptual that we can then come back to. Might I suggest that perhaps you work with the LSO prior to committee of the whole and offer a committee of the whole amendment, if you get the language right and where you want it, and bring it to us in a more defined manner?
That'd be fine.
Okay, thank you. Moving on, page 3, Representative Webb.
Thank you, Mr. Chairman. Just for my clarification, lines 5 through 7, particularly lines 6 and 7, except when done as part of a recognized medical procedure. Do we need to specify that that medical procedure needs to be performed by a licensed medical person versus somebody that just claims that they are in self-defense, saying that that's why they performed that? Does that make sense?
Representative, I would think that the recognized is the applicable term there, that, you know, if your 18-year-old friend in the dorm is performing the practice, it's probably not a recognized medical procedure. Does that help?
Yeah.
Sorry, as long as that is in there, I just don't want there to be some type of a defense there that the 18-year-old friend is can get away with this.
I'm open to an amendment. I think recognized covers it, but if a representative wants to bring an amendment, we certainly can. Representative Lean.
Thank you, Mr. Chairman. The good representative brings a valid point. There was recently a case in which a podiatrist was grooming children and then sexually abused them, and that happened here in the state of Wyoming. And so I would offer an amendment to say, as part of a recognized medical procedure performed by a licensed medical professional.
Second.
Okay, you want to state that again? I will make sure Pierre's got it.
On line 7, after procedure performed by a licensed medical professional.
Everybody clear on the amendment? We have a second by Representative Filer. Discussion on the amendment? All in favor of the amendment, say aye.
Aye.
Those opposed, no. The amendment carries. Further amendments on page 3.
Mr. Chairman.
Mr. Vice Chair.
Maybe. Okay. Thank you, Mr. Chairman. I'd like to make an amendment on page 3, line 5, to strike the word vagina and replace it with genitals. So that way it fits all the equipment. So, thank you.
Is there a second? Second by Representative Lean. Can you penetrate all of the genitals, Mr. Vice Chair?
Mr. Chairman, I just wanted to make sure that there was coverage of both male and female parts. So to write that broadly.
Representative Chester.
Thank you, Mr. Chairman. I think on line 6, or rectum covers it. So I think vagina or rectum covers both genders.
Mr. Vice Chair, interesting discussion for our morning.
Thank you, Mr. Chairman. Yeah, well, yeah, I would say that saying if it was demonstrated as a penis as well, that ought to be covered in this legal definition.
So did we have a second on that amendment? Representative Filer, did you have a second on that or not? No? Do we have a second? Representative Lean? So we have a motion and a second. Any further discussion on this motion? All right, all in favor of the motion, which is to substitute the word genitals for the word vagina on line 5, page 3. All in favor, say aye.
Aye.
Those opposed, no? No, that motion fails. Further amendments on page 3. Page 4. Anybody have something on lines 21 through 22, the age gap issue that Representative Landon brought? Anybody? Would you be open to some committee of the whole amendment work? Very good. Anything further on page 4? Page 5?
Chairman?
Oh, sorry. Representative Filer?
Yeah, and yes, Mr. Chairman, I think Representative Lean and I, we're going through all these definitions while we're going through this bill. And on lines 13, we have sexually explicit material, which is actually not defined in our statutes. I don't know if we need to add definition. This could be a committee of the whole amendment or something like that, but there's a lot of different definitions in obscene, how obscene is defined in statute and all that, but we don't have the sexually explicit material as a definition, but that could go back to a lot of other definitions where they could use that. I just don't want to not have something in there or how to reference it correctly.
Understand that.
Yeah.
If you don't have something specific this morning, maybe a committee of the whole amendment is the best way. Representative Lean?
Thank you, Mr. Chairman. For our attorneys, if we were to strike sexually explicit material and insert child sex abuse materials, would that give us a more concise distribution of materials that we are trying to avoid?
Yes, in our statutes, we still use the old term child pornography. We have not updated our statutes to child sexual abuse material, so it's not probably defined using that language. Want to wait for committee of the whole? Representative Filer?
Yeah, I think.
Very good. Anything further on page 5? Representative Chestick?
Thank you, Mr. Chairman. I think we're developing a theme here of we need to do some more work on a committee of the whole amendment here, because I also flagged, and thank you, Representative Brown, for calling attention to the problems with the penalties on page 5 and 6. I think there's some inconsistency. I think they might be too high. Because it affects really subsections C, D, and E on pages 5 and 6, we need, I think, a comprehensive amendment to reconcile them with the sexual assault maxes that the problem that you pointed out to us. And also, I think the penalties up to life are just not appropriate. Some of the penalties are just too high. So Representative Brown, would you help us with a committee of the whole amendment to clear this up? Because thank you, appreciate that. I have nothing to offer here except we do need to have a fix, and that might have to take place at the committee of the whole.
Just a comment for the committee going forward. this is a good lesson as we get going again in a session. Really important to think about amendments before we get here. Because when we go on the floor in committee of the whole, the body's expecting that the committee has done its due diligence on this legislation. And then when we show up on committee of the whole with 9 amendments, think about the message that that sends about the work of the committee. So that would be my concern. Public comments closed. Yeah. Representative Ling.
Thank you, Mr. Chairman. I'd like to offer an amendment on page 6, line 4, to strike from the word of through line 5 to the end of law and insert up to 10 years. And on line 12, strike not less than and insert up to, strike 25 and insert 15. On line 13, strike 50 and insert 15,000.
Second.
Okay, so that's you say 15,000, 15?
Yes, sir.
All right. Pierre, you catch all those? All right, so page 6, line 4. We're striking not less than and inserting up to 10 years.
From the word of through the word law on line 5 and insert up to 10 years.
Okay, and line 12.
Line 12, strike 25. Oh, I'm sorry, strike not less than and insert up to, and then strike 25 and insert 15 years. And on line 13, change 50,000 to 15,000.
Pierre has it. Committee, are you all clear? We had a second by Representative Filer. Discussion on the amendment? Ready to vote? All in favor of this amendment, say aye. Aye. Those opposed, no.
No.
Okay, amendment carries. Further amendments on page 6, Representative Shestak.
In light of what we just did on page 6, I want to go baback to page 5.
Going back to page 5.
Yeah, and that on line 20, change 10, lines 20 and 21, change 10 to 5. So the standard is 5 years. If it's under D, when there's you have a younger victim, it goes up to 10, and an even younger victim under E goes to 15. So that makes more sense, 5, 10, 15.
Is there a second?
Second.
Second by Representative Lane. Discussion on the amendment?
No.
No discussion? Representative Bratton? Repeat the amendment?
Yes, on page 5, line 20 and 21, change 10 to 5.
Pierre, you got that?
Yes.
Okay, committee, all in favor of the amendment, say aye.
Aye.
Those opposed, no.
No.
That amendment carries as well. Further amendments, page 6. Page 7. Page 8.
Mr. Chairman.
Mr. Vice Chair.
Thank you, Mr. Chairman. I wanted to ask LSO, it seems kind of strange to me that we're putting in the definitions as otherwise defined instead of having all of the definitions in the definition section. And so I was wondering how common that is in statute.
Unfortunately, we don't have a LSO attorney.
Oh, I'm sorry.
During sessions.
Shoot.
Only during the interim do we have attorneys available to help us with. those
Thank you
sorts
for
of
that correction, Mr.
All right.
Chairman.
Anything else on page 8? Page 9? All right. Let's have a roll call on House Bill 9 as amended.
This is a roll call vote on House Bill 9 as amended. Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Excused.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused, as amended.
Representative Lean, did you want to carry this on the floor? Very good. And with that, that concludes our work for today. We'll be back hard at it. We'll probably have 3 bills on Friday, so we'll need to work very expeditiously to get through the work. I'll announce with setting when we publish our notice for Friday. So plan on coming well prepared with any amendments, and we will go to work on Friday. Also a reminder tonight for the committee, 5:30 in the auditorium, we have a special presentation for the committee. So with that, we stand adjourned.